मंत्री जी आप शुरू कीजिए।
Sir, I rise to respond to the
मंत्री जी बोल रहे हैं।
queries and concerns of the honorable members after I moved the official amendments to the Anti-Maritime Piracy Bill 2019. First of all, sir, I would like to thank all the honorable members across the House, because I think everybody has looked at this initiative very positively. There is a broad recognition that our country requires anti-piracy legislation. It is part of our international responsibilities, and I think by and large I can see there is unanimity about the bill. I also, sir, want to particularly thank the Standing Committee. The chairman of the Standing Committee, Shri P.P. Chaudhary ji, had to leave just now because he had a Standing Committee meeting. But I want to put on record that he and his colleagues of all the parties who are members of the Standing Committee, they have made many invaluable suggestions. Out of the 18 recommendations, we have taken almost every one of them on board. And their recommendations, I want to say, have greatly helped in getting the right balance in this bill. Now, before I come, sir, to the points which were raised by individual members, I want to clarify one issue which came up, which was the question of government amendments, because I think some honourable members were either they had not seen the amendments, they were not aware of the amendments. Shri Manish Tiwari ji actually in his remarks said it was presented at very short notice. I want to put on record that actually government amendments were moved in the last session, in the monsoon session. They were moved in the business which is there for the 3rd, 4th and 5th of August, and the amendments were actually uploaded on July 22nd. That was in the last session. In this session, before we had the debate on the bill, there was again an uploading of the official amendments on December 6th. So I want to be very, very clear and on the record that all that has been moved by the government side is very much available to members, and that it was our expectation they would look at it. Now, the interesting thing is, even though some honourable members perhaps could not, for whatever reason, see the amendments, actually almost everything that they said, what the honourable members said, what the Standing Committee felt, and what is the government amendment, actually converges. So it is not that we are at cross purposes with each other. Actually, most of the House is converging on pretty much the same issues, and I will address some of the issues. Before coming to individual members, sir, I'd like to focus on 3 or 4 common issues or important issues, some of which Shri Adhir Ranjan Chaudhary raised, some raised by some of the other members. And I think the most important of this relates to the death penalty issue. Now, what we have done, sir, is in the bill, under section 3, 4 and 5, there is a range of punishments. There is a range of punishments which have been provided depending on the gravity of the offence and the extent of the culpability. So, for the sake of clarity, let me state that under section 3.1, whoever commits any act of piracy shall be punished with imprisonment, which may extend to imprisonment for life or fine or both. And the official amendment has provided for, has taken from the earlier punishment for life into, which was the only provision, has now actually done punishment extend to life or fine or both. Regarding death, the provision for death, under subsection 2 of section 3, earlier on there was a provision for death. Now that has been amended as per government amendment to punishment with death or with imprisonment for life. if such a person is committing the act of piracy and causes death or in an attempt thereof. So I want to assure the House Speaker, sir, through you, that the concern that there will be a mandatory death sentence is no longer relevant in view of the government amendment, which actually provides for death or life imprisonment depending on the nature of the circumstances. This is in keeping with the Supreme Court pronouncement, which many honourable members also raised in their remark, which is that death should be rarest of the rare. So that flexibility is there in the amendment to the bill. We have also kept in mind that extradition, many countries will not extradite if there is a death penalty. So that flexibility is also something, and some of the other members also mentioned that in their remarks. The second issue, sir, is the issue of graded punishment. Now, there are different articles and different levels of punishment. Under Article 3.1, for committing an act of piracy, you could have up to life imprisonment. But if someone attempts to commit or aids or abets or conspires or procure, that is then can be imprisonment for a term which may go up to 10 years. So it is a lesser offence. The punishment envisaged is lesser. If someone has participated or organized or directed another person in an act of piracy, the punishment for that is 14 years. So we leave it, sir, to the court to make the judgment depending on what is the culpability of a person. Accordingly, that option for the punishment is there. Then, sir, many honourable members raised the issue of the concern about presumption. So I would like to clarify, and this was a point which the Shri P.P. Chaudhary made when he was speaking in terms of the Standing Committee recommendations. It is not an open-ended presumption. Supriya Suleji, I think, expressed that concern, that it should not be that by presuming that government has the right to take action. There are very specific conditions relating to presumption. Condition number 1 is that arms, ammunition, explosives and equipment must be recovered. Condition number 2, there is evidence of the use of force. Condition number 3, there is evidence of an intended threat. So unless these conditions, which prima facie show that some act of piracy has happened, and even there the presumption is unless the contrary is proved. So I want to say very, very clearly that this is not a case where you are presumed to be guilty unless you are proven innocent. There has to be evidence on 2 cases, or there has to be a recovery in order for the presumption to take place. So I hope honourable members are reassured in this matter. Then some members, sir, raised the question of international cooperation. Now, we have the whole purpose of the bill is also to promote international cooperation. And I think many honourable members and the Standing Committee pointed out that we have been members of UNCLOS ratified it since 1985. We have not pursued the subsequent legislation to deal with piracy offences, and it is important we are seen as a responsible international player. Today, sir, correct. So we are today members of the RECAP, which is an arrangement of 20 countries in Southeast Asia, which happens incidentally to be headed by the former chief of our Coast Guard, Mr. Natarajan. They deal with armed robbery and piracy in Southeast Asia. We are part of the contact group on piracy of the coast of Somalia, because there is a lot of piracy out there. We have been in the Gulf of Aden. We have deployed since 2008. We have also now joined the combined maritime force based in Bahrain. Sri Manish Tiwari ji had raised that issue. The matter had been under consideration, but we came to the conclusion that the benefits of joining were more than of not joining. And in fact, for the first time, one of our ships has taken part in an exercise called Operation Southern Readiness as part of the CMF. We have also engaged with regional navies. We have engaged with foreign friendly countries. We have done EEZ surveillance. We have done coordinated patrols. We have created a maritime domain awareness system. And we have a fusion center in Gurugram, which actually gets data from the entire Indian Ocean area so that there is better maritime security. Then, sir, the issue of our fishermen was also raised. I think Sumati ji raised it. Now, I was, sir, in a dilemma when she brought up the issue, because she said that Government of India is giving stepmotherly treatment because Tamil fishermen and fishermen of the Gujarat coast are treated differently. Now, I'm a Tamil elected from Gujarat, and I was really not sure which side of the picture I give, because the other side would react. So I want to give a win-win answer, sir.
वो तमिल के गुजरात से चुनकर आए हैं।
तो सर संसद को मैं ये बताना चाहता हूँ सर, मैं खाली आंकड़े दूंगा, तो it is for the house to judge, and I am taking from 2014 because that is when the Gujarat argument started. So from 2014, the number of Indian fishermen released from Sri Lanka are 2,835. The number of Indian fishermen released from Pakistan, apprehended off Gujarat coast, is 2,165. So 670 more Tamil fishermen have been released after 2014. So I want you to, the honourable member, sir, to be very reassured. There is no stepmotherly treatment. In fact, there is very good fatherly treatment. Yes. And I, sir, want to make a very serious point here. If there is any government, any leader, any prime minister who has given attention to the problems of the Tamil fishermen, it is Narendra Modi. Yes. It is Narendra Modi, because we have, during his government, set up a mechanism with the Sri Lankans to take up fishing issues. He has himself spoken to the President and Prime Minister of Sri Lanka on repeated occasions. He has asked me to deal with the Minister of Fisheries and other ministers on this matter. And the fact is, sir, that if today fishermen apprehended in Sri Lanka are being released, let us be clear, they are not released because somebody in Chennai is writing letters. They are released because somebody in Delhi is taking up the matter. So I would not like this to become for us. Fishermen are fishermen, please, whether they are in our southern coast, whether they are a western coast, yes, whether they are a eastern coast. We will treat them all equally as our citizens. I would like all members to be reassured on this matter. If I can move on, sir, to my...
will be there.
So I can...
अभी तमिल और गुजरात संगम चल रहा है, बैठ जाइए.
Sir, I would also then move to the next issue, sir, which is the issue which many members raised about whether there should be the consent of or consultation with Chief Justices when specifying designated courts. In this matter, sir, we were guided by the Ministry of Law and Justice, citing precedents. And the precedents are the Prevention of Money Laundering Act 2002 and the National Investigation Act 2008. In both cases, special courts were set up. In both cases, this were done with consultation of the Chief Justice of the High Court concerned. So I want to say that we followed that particular precedent. Then we came, sir, to the issue of various ministries. I think members wanted to know, have the roles of different ministries been defined? I want to assure them that there are already standard operating procedures and contingency plans. Depending on the situation, Ministry of Shipping has its own plans and SOPs. Ministry of Defence, Navy has its own. And our effort in the Ministry of External Affairs is to coordinate it. So again, I would like the members to be assured that this is being taken care of. Then, sir, I would like to, with those broad remarks, I would like to address some specific concerns which individual members had made. I will start, sir, with Shri Manish Tiwari ji. He had sought an amendment to the title of the bill saying Maritime Anti-Piracy Bill, not Anti-Maritime Piracy Bill. I want to assure him that is part of the government amendment. It has been taken care of. Regarding the Combined Maritime Task Force, I have already spoken about it. We have weighed the pros and cons and decided to become a member. He spoke about what we are doing to ensure greater security in the Western Indian Ocean and Arabian Sea. I want to assure him that we are working with our various partners in the region and our maritime cooperation there has become very much stronger. The death sentence issue I have already dealt with. He had referred to the word, there was a word, sir, in clause 4 on the word counsel, and he felt the word counsel was not the right word. We agree with him. The government amendment has replaced counsel with conspire. Then there was a concern he expressed that under clause 9, Indian nationals on board a foreign ship may have been hurt due to piracy, and we do not have the jurisdiction to try that. So we have removed that provision so that problem is not there. The presumption issue I have already answered. So in regard to the issues pertaining to the bill, I have responded to the concerns that he has raised. So if I could move to the issues raised by Shri P.P. Chaudhary. He had raised this issue that at where there should be a replication of word aids and abets and procures. But what I have clarified to him is that 3, 4, 5 envisage different levels of culpability, and the punishment envisaged depends on the seriousness of the offence, and we leave it to the judgment of the courts to actually exercise the latitude which the law gives them in this regard. Then, sir, Shri Brithari Mehtab had raised an issue that the presumption should be confirmed by the High Court within 30 days. Yes. So I would like to clarify to him that the presumption is not an unconditional presumption. The presumption has prima facie evidence. Twice the word evidence is mentioned, once the word recovery is mentioned. So our view is that the designated court will not presume about the commission of the crime without those conditions being met.